All right. Good morning, everyone. Thank you for joining our Ask the HR Expert. We are here today to cover a topic that I am sure you've heard a lot about. You'll probably continue to hear a lot about. Actually, two topics: the salary threshold, salary wage-based threshold for exempt and non-exempt employees, and also the overtime, also the non-compete ban. So those are two federal rules announced by two different agencies, and they have a lot of consequences coming up for employers of all shapes and sizes. So I'm going to cover those for you. Before we dive in, however, just want to do a little bit of housekeeping. We have muted everyone's line, everyone's phone, and that is simply because we want to make sure the audio quality is as good as possible. It does not mean we don't want to hear from you. In fact, the opposite is true. We want to hear from you. So the way that you can contact us through this presentation is if you look at the toolbar down at the bottom of your screen, there should be a little box with a question mark in it, Q&A. Pop that open. I've got it open on my screen here. So if you have any questions, anything that you think of while we're going, feel free to put it in there and I'll try and integrate it into our conversation. If I'm not able to get to it during the conversation, we will have time at the end and we'll just open it up for everyone for any questions that you might have. We are also recording the webinar today. So if you registered for the webinar, you're going to get an email after the presentation, and that's going to have a copy of the webinar recording. If you didn't register for the webinar, but you'd like a copy, please just shoot me an email. My contact information will be at the end, and so you can get a copy of this. Let's see. You may have, if you are a client of Tandem, a current client of Tandem, this will probably sound familiar, this topic, because we did a client workshop on this topic back on May 7th. So a lot of this will be familiar to you, but there have been some updates since that workshop, and we're going to cover those at the end of the presentation today too. So I have a couple great panelists with me. I want to give them a few minutes to introduce themselves. So Kirk and Eric, who wants to kick us off with introductions?
Go for it, Eric.
Yeah, thanks, Marcus. Eric Morse here. Been with Tandem HR for 6+ years. Excited to be back with everybody here today and to cover some of the thresholds, FLSA topics, so to continue to help businesses be compliant. So we'll cover that topic myself personally on that, and I'm going to kick it over to Kirk.
Thanks, Eric. Yeah, my name's Kirk Davis, Senior Director for HR Client Relations. I've been at Tandem for just over 2 years now. My past life was an employment law practitioner, so I've navigated this space from a reactionary point of view, like what do we do now? And now I'm trying to navigate it more proactively as we're giving advice to clients to kind of figure out how they work around some of these issues and plan for some of these significant changes. So excited to talk to you all about the changes and some of the implications for your business.
All right. Thanks, guys. My name is Marcus Wilbers. I'm the Chief Client Officer and General Counsel here at Tandem. Happy to have you with us. We do these on a monthly basis, these Ask the HR Expert webinars. So this is the first time you're joining us. Welcome, and hope to see you in the future. So we'll go ahead and get started, guys. Can you give me a thumbs up? You can see my screen? You guys can see my screen. Awesome. So what we're going to cover today, we're going to do a little bit of an introduction and kind of orient you to the rules that we're going to be talking about. Then we're going to cover each one in turn. We're going to cover the new threshold for the overtime exemption. We'll make sure you understand what that is and what the new rule is, how that's going to change things for you. We've actually had some change already. We'll have some change coming up again in January. Then we're going to shift over to the non-compete agreement ban. So that was by the FTC, so a completely different federal agency, but it does impact employers. And so we want to make sure that you understand what that is and how you can go about addressing it and help protect yourself. Then we're going to cover a couple recent developments. There have been some litigation about these new rules, so we want to make sure you understand what that is. And if going to make a prediction, we'll probably have to do another one of these webinars at some time in the future, because I think there are going to be continued developments coming out about it. So we will all be sick of talking about both of these topics by the time the dust settles, I'm sure. So a couple things that we're not going to cover. We're not going to do a full-on analysis and discussion of all of the Fair Labor Standards Act or FLSA exemptions. We'll do kind of an introduction to that so you kind of understand what those are, but we're not going to cover all of them. This is not meant to be exhaustive. We're also not going to cover when non-competes, when you should use them, when they're going to be enforceable or not enforceable. If you've ever dealt with that, you might understand that that's a little bit of art and science, non-compete bans, when they're enforceable, when they're not. So we're not intending to make this a discussion about non-competes and when you should use them. We're also not going to get political at all and tell you that we agree, disagree, think these rules are silly, well-considered, or well-timed. The rules are what they are, and we want to have a very factual discussion about what the rules are and how they might impact you. Let's see. I guess one first thing to address is what's the point of all this? What are we doing here? So what are we hoping to accomplish? We hope you walk away with an awareness of one, what the rules are and how they change what the existing employment laws are. We also hope you have a snapshot of the landscape now, how these rules fit into the broader context of the employment laws that you're responsible for complying with. I hope you understand that litigation, we'll talk about some of that, but there's always the potential for more litigation, how that could impact these rules. What we're going to tell you today is what we know today, what we know to be true, but that does not mean that something can't change, next week or next month, and that would change the advice that we would give. Also going to cover a little bit about how to approach these rules. So knowing what we know now, how should you go about approaching getting your organization into compliance, and who should you work with, and just, what the next steps might be. So that's what we hope you get out of this today. So with all of that said, let's dive in and let's start talking about the exempt salary threshold. So this is a Fair Labor Standards Act regulation. So I'll turn it over to Eric.
Thanks, Marcus. So here at Tandem, our HR business partners, one of the main focus areas with each one of our clients we work with really is an area of focus is the Fair Labor Standards Act. And just the Fair Labor Standards Act covers many areas, but three primary areas is youth employment, minimum wage, and overtime. Today, we're going to talk specifically about overtime and what that means to your organization and what kind of has happened, what is going to potentially happen down the road. But historically, from a context standpoint, kind of want everyone to kind of understand what does an overtime exemption truly mean, where it is prior to July 1st, and where we're going with that. So with that, there's two specific areas of the Fair Labor Standards Act when you're talking exemptions to overtime. And there's two typically standard classifications. There's a salaried exempt employee, hourly non-exempt employee. Those are your two most common defined employees, if you will. And today we're focusing on your salaried exempt employees, and four specific categories. Today on this slide right now, we're looking at, you may hear the term EAP, but at essentially executive, administrative, and professional exemptions. With that, there's two components in identifying whether your employee would fall under this exemption. And I say this subjectively, there is a job duties test where that one is a little bit more, I said, subjective in nature in identifying what specific roles and responsibilities that employee will be doing for your organization. And then there's a salaries test, which there's a mandated salary that you would need to pay your employee to make sure that they're exempt from overtime. So Won't going to dive too far into the bullet points as far as the specific job duties today, but this screen or this slide highlights what it was prior to July 1st. So back in January 1st of 2020, historically, the wage and hour division passed a ruling that increased the salary threshold to $35,568, $684 weekly for any employees that fell into this category. So from 2020 up until July 1st of this year, there has been an update. We're going to get to that in a minute. But just historically wanted to just cover where we were and now where are we today, and then where are we going, January 1st of 2025, potentially.
So Eric, you mentioned there's hourly employees and there's salaried exempt employees. Is it true to say or fair to say the default is employees are hourly and they are entitled to overtime unless they qualify for an exemption? Is that fair?
Absolutely. So,
okay.
Yeah. So job description creations, again, Tandem and your HR business partners, another very strong focus area of when determining an employee, whether they're salaried exempt, is making sure a job description really is strong and meets the required job duties of that exemption that you're classifying your employee. So by default, you'd want to probably look at an employee as hourly, non-exempt. But then, if we're making that position salaried exempt, job description creation is really important as it following each one of the exemptions job duty tests.
And I think that's important. I bring it up only because I've had conversations with clients in the past, like, well, let's just pay them salaried. Like, well, it's not entirely your choice. You have to, the person's job duties, like you said, and their salary have to meet certain requirements in order for you to pay them like that.
Yep.
Yeah, I think that's if I can jump in real quick, I think that's an incredibly important point to kind of pause here and highlight for the audience, is that this isn't just about salary adjustments, right? It's not just about moving people so that you don't have to think about this anymore. It truly is about evaluating each position, what they do, where they fall within the organization, how they fit, and examining and kind of scrutinizing those responsibilities that individual is going to have, because there is a lot that is included in this process. It does need to include job descriptions, maybe salary ranges, a job analysis or review. So there's a lot more that needs to happen here than just one thing. We move the needle and then we can move on.
Yeah,
absolutely. All right. Okay. And then on this slide here, guys, we have another exemption that we want to talk about is highly compensated employees. I'm not going to focus too much on this one, but this one's more unique, if you will. It is a classification where if you have an employee classified under this, there's a salary minimum wage of 100, and this was prior to July 1st, $107,432. You can see there. But they would only have to meet one of the white collar job duties tests as described there. Not going to, again, go into major detail there, but this is one of the other exemptions that was impacted by this new ruling for the overtime exemption threshold. So just another topic that we can help clients with and navigate through on classifying employees, whether they are an EAP or a highly compensated employee.
Yep. So like you said, there are a number of exemptions. We're going to talk mainly about 4, the 3 on this page and the 1 on this page. So here's what's changing, Eric.
Yeah. So as of July 1st, you may or may not have heard, we did have an increase to the threshold. And that number jumped from 35,568, as I shared, for the executive, administrative, and professional exemptions to $43,888 annually, coming out to $884 per week. For your highly compensated employees, that jumped to $132,964 annually. Again, this is, as we discussed previously, again, reviewing, job descriptions and things like that. And we'll go into the next slide of talking about a couple other practices that we'd recommend. But I really want to highlight this bullet point 3 here, that the salary thresholds for all 4 of these exemptions are going to be automatically updated and reviewed every 3 years. And as we know, you know, with the economy, there's fluctuations with that. So things can increase, but also if there is a downturn in our economy, the rule specifically says thresholds can decrease as well. So just want to be clear on that, depending on the nature of, you know, the stability of economies and things like that. Again, that's what was put into this rule as it was published, that every 3 years it will be reviewed. So, you know, subject to change in 3 years, but just want to make that clear for the audience today.
I think another point here to highlight for just planning purposes, and as we move into our discussion about what the changes are and the potential litigation challenges that we're going to see, I think this is the thing that quite honestly makes the rule most likely to be challenged, is that previously this automatic update was not in place. We had revisited it. There were opportunities for comments, and people got to provide some feedback about those salary thresholds. This assumes that none of that's going to happen, and it's just going to automatically be an agency adjustment. I think this is where we're very likely to see some court challenges to this, because we haven't built in that process for those changes.
Yeah.
Yeah. Go ahead, Eric.
No, I was just going to say, just and just a caveat with what Kirk just said, you know, challenges being made in the upcoming months prior to January 1st. You could see on this screen here that as of January 1st, if things were to stay status quo, the bump in salary increase to 58,656 and then 151,000. So subject to be challenged possibly, but I don't know, Marcus, if you have anything to add there.
Yeah, I was just going to say, I think you know, how this gets updated, how that, you know, annual salary amount, the agency reaches that determination. I think Kirk's right. That's, you know, that's the most uncertain part of this. You know, I think if I put myself in the agency shoes, they're probably trying to have this keep pace a little better with where wages are. Before this update, you may remember we kind of went through this, gosh, what was it, 2018, or was it before that? It was several years ago. The agency announced an update to this, and it was challenged and ultimately not enforced. Before that, the federal the salary threshold had stayed static for decades, right? So, you know, the original intent was, well, let's make people who are making a good salary, we can excuse employers from paying them overtime because of the salary, but if you don't update that threshold, it gets a little out of whack, and that's why, you know, I think the agency wanted to address it. So, but I know, you know, these amounts impose real burdens on employers. So, Kirk,
Yeah.
do you want to jump in?
Yeah, you're absolutely right, Marcus. Like, we haven't seen this since the Obama administration in 2016. So it's a significant change. And when you look at, I mean, I think the agency was right in their approach that we want to stagger it so it doesn't have this immediate impact on employers. But if you look at what's happening from July to January with these total increase, I mean, this is a 65% overall increase for salaries. So it's a hugely significant impact and burden for employers. We absolutely want to make sure that people are being compensated for the work that we're doing, but employers are having to scramble. I mean, those are two changes within one budgetary year that they most likely have not accounted for. So we definitely want to caution you to be proactive, to think about this, try to get in front of it as much as you can. I do highly suspect that we're going to see some more challenges and changes here, but this is going to have a hugely financial impact on organizations.
We have some questions, and they're good ones. So first question, to be clear, the increase for January is not a mandate yet, but we should plan it will be.
Absolutely correct. Yeah. If we're marching along the same time frame and the same agency restrictions that we're seeing, that's absolutely what's going to happen. They're telling you what it's going to be so that you can proactively plan and budget for that.
Yeah, I'm probably like over lawyerly analyzing this, but like it is a mandate right now. You just don't have to comply with it until January 1st.
And I'd just add, from Tandem HR's perspective, I've said it a few times, we have tools and resources to help your organization prepare for that. Again, reviewing job descriptions, reviewing FLSA checklists, which we'll get to on the next slide. So it's a great question to segue into the next couple slides we'll be talking about. So great question.
So here's another one. If you don't see the need to increase the base salary of people under total of 58K, can't you just move them to hourly? What do you guys think?
I think it goes back to our previous comments, right? Like, there are clients that are actually going to make that move, but then you've also got to engage in the adjustment with looking at your job description, reporting structures. There's a lot of infrastructure that could potentially need to change for those individuals as far as timekeeping systems and monitoring those hours. So I think that is an option, certainly, but you need to explore the total cost of making those moves.
And I'll just add, if there's a group of employees in a certain position, just need to be careful about discriminatory practices, just because, I don't know, regionally, you may have certain, I'm just going to say controllers, accountants as an example, that may be getting certain different pays, or, they perform X, in an X different number of ways for your organization. So just moving them to an hourly non-exempt role does come with some risk, but really identifying, the reason why you're moving them to hourly non-exempt is a critical part of the analysis. And again, as Kirk shared, job description reviews, really understanding, why we're making that move is important. And, there is risk associated with just taking salaried exempt employees, and moving them to an hourly non-exempt, especially if they've been doing the same role for 3 years. However, this is a good time and the perfect position to say the government's made these updates, to have these conversations with your employees and your HR team.
Yeah, I think just moving them. Okay, say they make 50,000 right now, and you're treating them as exempt. Just moving them to hourly instead of moving them to 58. That does address the Fair Labor Standards Act issue, but I think, as both of you pointed out, there are a lot of other issues that it raises. Like Kirk, I love that you said the time clocks and things like that. Like, how are they going to clock in and out from a financial standpoint? Are they working more than 40? Like, are you going to end up paying overtime? And then there's the human element to it. People, I think, will perceive it as a demotion, even though in real terms, they're actually eligible for more comp. And Eric, I like what you said too. Like, if we have 3 or 4 people in the same or similar role, just moving one of them to hourly could create some problems from a discrimination standpoint. Yeah. Couple more questions. If someone is a 10 or 11-month employee per their contract or letter of appointment, would the required salary be the weekly rate, now $884, times the number of weeks their letter of appointment or contract states? Or do you go by the annual?
So I believe within the rule itself, there is an accommodation for those type of specific situations. So you would annualize that out, as opposed to looking to specific contract terms. So that's what they're probably going to be focusing on. But again, that's a very specific scenario that would require you to get in, kind of look at the specifics, look at what that time is allocated for, why we're not doing it one way. So that would require probably a much more complex analysis.
That's what I was going to say too. It seems like there's a lot of specificity with that. So that, the person asked that question anonymously, please reach out to us if you want some guidance on that, because there are a couple other things that are going through my head too. Last question before we'll move on. Can you please say the definition of highly compensated employee one more time? So let me just do this. Highly compensated employee salary threshold was 107,432 annually, and they have to meet one of the duties of exempt administrative or professional employees. So to qualify for administrative, you have to have the salary plus these duties, and you have to meet all of them. Executive, you have to meet all of them. Professional, same thing. For white collar, you just have to meet one, but there's a higher salary. Great questions. All right, Eric, how
Yep.
should employers move forward from here?
Yeah, we did hit on a couple of things during our conversations here today, but just again, here at Tandem, our HR business partners, what we can do to help businesses is first and foremost, identify your employees impacted. So, right, just doing an analysis, reviewing salaries, and reviewing exemption statuses, right, and just kind of creating profiles for each one of your employees. And then we also, again, as I mentioned, have tools and resources. And I really wanted to, again, stress the importance of job description management, and then also just understanding each role and why we are identifying this position under an executive, administrative, professional, or a highly compensated role. So we do have checklists and tools and resources that we have available to our clients. So that would be the first step at that point. And then with that being said, we take that information to our clients. Clients and employers would, obviously need to take that information and see what's best, as far as, from a budgetary standpoint. And again, as I mentioned before, this is an opportunity to really identify your positions, and should they be considered should we switch them? Should there be an hourly non-exempt role, and when we do this? So if you haven't done an FLSA audit, and when I say that is really taking a closer look at your job descriptions and how you're classifying your employees, now is the time. And again, as we prepare for January 1st, we have, again, five more months, 6 more months leading up to that. This is absolutely the time that, we would, recommend strongly doing that and not wait till last minute. So again, as Marcus, you said, if we're switching, instead of like moving these employees to the new threshold, and we haven't done that on July 1st, really, we need to get that done and then prepare for January 1st. And with that being said, if we're thinking about moving employees to hourly non-exempt employees, time and attendance, what does that mean for overtime? And just really understanding that and, making a strategic plan for our businesses out there. So those are 2 specific areas and recommendations we can help assist, and we recommend employers do.
Yeah, and I think, Eric, I'll just give an example. I was kind of coaching and counseling a client through this recently. And if we're looking particularly at this step number 2, where we're weighing alternatives, the client reached out and said, hey, can you show me what the financial impact of this decision will be across the board? Of course, we can give you that. And they were going to make a quick judgment about, well, it looks like it's going to have this kind of financial impact. Let's just go ahead and move them to be hourly employees. And I said, well, wait, you want to look at what are these employees actually doing by way of potential overtime. So once we shared that information with them, and they were able to see that most of these employees that they were going to move were going to be looking at 10 to 20 hours of overtime apiece, the financial impact of that decision was far greater than moving their salary. So you have to absolutely look at the entire picture here and be thoughtful and partner with people to kind of think this through as far as what the impact is going to be. Like Eric has said, like, it's not just one thing. It's not just the timekeeping system. It's not just the communication. Think about the morale. Think about the conversations that you're going to have. Think about the administrative time that's going to be dedicated to having conversations with potentially hundreds of employees that are going to be in this situation. So look at it holistically and make sure that you're making the best decision for your organization.
And we have a question, but let's finish out steps 3 and 4 before we get there.
Yeah, and before I dive into that, just one caveat to just add on to what Kirk said, and when we're evaluating this, and as we know, as many employers have gone to a remote workforce and have hired throughout different states,
Yeah.
It's very important from a compliance standpoint. Each state may have a different interpretation of overtime law. laws. So, the most common, right,
That's a great
overtime
point.
is over 40 hours worked in a work week. However, some states have an 8-hour daily overtime rate. So really understanding what specific states and what their overtime laws are is an important consideration in weighing that. So just wanted to throw that out there
Excellent,
to make sure.
excellent point.
Yeah,
Excellent point.
good point. Yeah.
So as we've kind of talked about, just really developing and when we make these decisions and when we're ready to make and act on those, developing a communication and training plan, being transparent with our employees, having private conversations with those impacted. Again, management training is, I think, critical in this. So the executives of the organizations, making sure they're having conversations with management, mid to senior level managers, directors, and organizations, talking about what this means for their organization, making sure there's clear communications from top down. Again, if we're implementing time and attendance systems, if that's something we don't have today, making sure employees understand what that means for them, why we're doing that, things of that nature. And then lastly, again, July 1st is coming past. If you haven't acted on it, really strongly encourage you that you do. And then coming, as we've said, January 1st, plan as if this is going to happen. We know there's an election, not to get political, coming up, and challenges may be coming more and more. So again, just really plan. Tandem HR has tools and resources that we can be here to support. And Marcus, Kirk, anything to add on FLSA here?
I
Good,
think
Kirk.
particularly with step number 3, again, just because I've recently been through this with several clients, I had a client ask me this question: well, can't we just send out a mass communication to those employees that are affected? And I would say, absolutely not, right? Like, best practice here is you're going to have one-on-one conversations with employees, and there's nothing more sensitive for an employee than their compensation, right? So you should be carving out time to make sure that you're walking them through the why, helping them understand why these decisions are being made, communicating to them how this is going to change their day to day. If they're moving from salary to hourly, what does that mean for me? How am I going to have to clock in? Who am I going to have to report those hours to? And also just along the lines of good coaching for them. Like, you're not to be responding to phone calls after the normal work hours. You're not supposed to be doing those things because it's going to be a lifestyle change for them. So I think along with these changes, you have to think about good leadership in this as well, and making sure that you're having good coaching and counseling sessions with these employees, because this is going to be a major change for them.
Yeah, and I was gonna, this is perfect because I was gonna highlight on step 4, wait for the dust to settle. So we're gonna do all this analysis. We're gonna plan. We're gonna come up with a communication plan, but I would pause before you communicate it because we don't know what the future holds. And you like Kirk and Eric said, we're gonna plan as if this is gonna happen, but you also don't want to be in a situation where you do all this planning and you communicate to everyone, hey, we're going to take you from this to that, we're going to make you hourly, or we're going to increase your salary. And then guess what happens? Say there's a court case that, bans the law from taking effect, or, bans the rule from taking effect. How do you unwind that? Right. Legally, there's one answer, but from a morale perspective, that's hard to recover from. So wait and make sure what's going to happen. So we do have two questions here. First one is, how are employers handling time clock reporting if they are in a hybrid role? Assuming currently it is a salary position, and then we may need them to move to hourly due to the new threshold. Hybrid role, I'm wondering if that means in the office, out of office.
Yeah, so just because the role is going to be hybrid doesn't mean that they're not going to have to record their time. So they should be recording their time when they're working in their home office, just like they're recording their time when they're actually physically at work. So again, that could be a significant change for people. So putting systems and processes in place so that the employee can make that easy transition and doesn't become much more work for them, right? So put a tool, put a spreadsheet, put something together so that everybody knows exactly what that looks like, and do training and communication around what that is.
And then another question we got is very similar. Thoughts on working from home for non-exempt employees?
I would add, I think that's a very, very good question, but I think it's really, based on your specific business and how your business operates.
Yeah.
Working from home works for some organizations. Some organizations more has, productivity is better of an on-site presence. So, managing your employees remotely, does have its challenges, but it also has a lot of pluses to it as well. But I will say from a technology standpoint, time and attendance systems, and especially, ones that we offer, there's apps. There's certain apps out there that can track productivity. So again, I think it's more of a organizational philosophy question that would need to be answered as far as what is best for your organization and how you want to manage that. I don't know if Kirk, you have anything to add there?
Yeah, the only thing that I would say there is I completely agree with you, but we just need to make sure that we're doing it consistently across the board, right? So we're not carving out something that just exists for remote employees. We're going to make sure that everybody's doing the same thing because, again, as the gentlemen on this call have mentioned, we want to make sure that we're being consistent and sensitive to potential discrimination claims. And if we're creating one system for a hybrid or remote workforce versus those that are in the office, we could run into potential problems.
Yep. Yep. I think from a technology standpoint, they can record time, like Eric said, on an app or on a web, even like a web portal for time and attendance. And then, the employer, it would really be up to the managers, I think, to manage the productivity is just because they're recording time, like is work actually being done? And you probably have, technology that can help you answer that question. All right. Let's move on because we are, let's see, 11:38 on my clock. So Kirk, do you want to lead us off on non-compete agreements?
Sure, we can kind of talk about this. I think the overarching communication that we want to convey is that the recent changes that we've seen here really do focus on non-competes, right? We're going to outline for you what non-compete, non-solicit, and non-disclosure agreements are, as this slide kind of indicates. But what we're really wanting to focus on our attention is the changes, and those really do affect non-compete agreements specifically. So when we're talking about a non-compete agreement, we're talking about something that would prohibit the employee from working at a competitor, right? Or a similar business or similar industry. What we see with most non-compete agreements is their focus on really two aspects. So they're focusing on a period of time, which we want to restrict those employees. And then they're also looking at some kind of proximity to the employee's location. What we're seeing for the trends and the changes here is that most are agreeing that this is too restrictive on employees because what the consensus is that employees should be able to work wherever they can find work, right? And too many restrictions just is too prohibitive of that. So keep that in mind. So that's really the focus, and those two prongs are key, is looking at the length of time that we're going to restrict and then also proximity. The other agreements, non-solicit, are really kind of protecting customers and employees, and it really does focus on kind of the lists, right? So it's prohibiting an employee from soliciting clients or prospective clients within a specific time frame after they leave employment. And then prohibiting an employee from soliciting employees of the company. So they know the great talent in the pool, and when they're trying to recruit over to the new organization, that can impose a burden for the employer. So that's what we're really focusing on with non-solicit. And then non-disclosures is what's prohibiting an employee from using or disclosing confidential information that they never would have had access to had they not been a part of that organization. So things that they would see, confidential documents or processes that are not disclosed outside of the organization. Those are the categories that we're talking about with all three of these types of protection.
Awesome.
So the new rule, how does it change? Well, again, keep in mind that we're really just focusing on non-competes. And the non-compete column that we were talking about really prohibits all employees except when used in conjunction with the sale of a business. That's important to keep in mind because when a sale occurs, those things kind of get shifted to the wayside, and we're not really focusing on those. We also hear that existing non-competes cannot be enforced against most employees because they're senior executives. I don't want to spend a lot of time there because the applicability is pretty rare that you see in that circumstance. And then employers have to provide notice to employees when existing non-competes that they have will not be enforced, according to this new rule. And then senior executives, just the definition here, are those that are making over $151,164 a year and who are in policy-making positions. So basically have some discretionary judgment in their position or their role. Again, if you look at the percentage there, this really does have a very small impact for most workers. So you're not going to see much applicability there. And then lastly, the rule takes effect 120 days after publication. So September 2nd is what we're kind of looking at, unless we see further challenges from the court, which quite honestly, we're already starting to see. So I think we're going to see about a significant flurry of activity here very soon that are going to challenge these agreements.
So similar to what we did for the salary threshold, we have, oh, never mind. I'm getting ahead of myself. So what won't change?
Yeah, so really what we're seeing again, where I'm coaching and counseling most employers is stay focused on your non-solicits and your non-disclosures. If you're trying to protect your business from an employer's perspective, this is where you want the meat of your focus to be, right? Move away from those non-competes, start thinking about the changing dynamic that we're seeing in the courts and the landscapes with these agencies. So businesses can still provide some protections here and can still get some guarantees for protections as specifically as it relates to relationships and confidential information. The FTC did leave open the possibility that non-solicits could kind of wreak havoc with this rule. I don't think we've seen that really flushed out yet. That's more of a wait and see. I think what we're going to probably end up with here is some diluted version of a non-compete that is not so restrictive on timing and geographical area, but that's kind of we have to wait and see what's going to happen next. And then also keep in mind that state laws govern these non-compete. So what is maybe applicable in Illinois or California won't necessarily be applicable in Missouri or more rural areas. So we've got to look at geographical rules, state rules as it applies to this, because they're the ones that are going to be enforcing these non-competes. And some states have enacted much more harsh restrictions here as far as the application. And we might have state laws, in fact, that actually conflict with the FTC. And that's where you're going to see some of these court challenges specifically addressing this. And then lastly, as it relates to senior executives, as far as these non-competes, again, because this is such a significantly small percentage, we don't want to enter into new non-competes because we don't really know what that is going to look like yet. My guess is, and Marcus, feel free to jump in here, is that that language is going to significantly differ from what we're using as kind of boilerplate non-compete language right now. So until that's kind of worked its way through the system and we've had an opportunity to kind of say, okay, this is going to fly or that's not going to work, we're not going to really have a good sense of what that's going to look like.
Yeah, I agree. I think if businesses really lean into non-solicits, non-disclosures, they can still protect themselves without introducing all the uncertainty of just a blanket non-compete.
Yeah, and I think that's the takeaway advice, right? Is that focus on those areas and not on your non-competes, right? So same analysis that kind of Eric walked through with the overtime thresholds. First step, you want to look at those employees that are potentially impacted. What agreements do you already have in place? Is it in offer letters? Is it in specific contractual relationship or agreements? So look at those. examine those and see which employees are going to be affected. And obviously your HR partners can help you with that. But we want to look at who those senior executives are and those people that have agreements in place. And then do we need to alter that, right? Do we need to remove the non-competes altogether and replace them with stronger non-solicits or non-disclosure agreements? So looking at what we really need to do proactively to take those next steps to put those protections in place, because obviously those things are still top of mind for employers that are dealing with those type of issues. Lastly, just like we've talked about before, is you really want to develop that communication plan. It's so important that we're not just making these random changes without having good communication to those people that's affected, right? Here's why we're making the change. Here's why it's necessary. Here's what we've done. Look at what you had, look at what we're proposing, and let's engage in conversation about what that's going to look like moving forward. And yes, lastly, as we've said many times before, let's just take a pause, take a deep breath, and wait, because we're going to see some changes to this as well.
The next step, we're going to talk about some of those changes, but this might be a good time to take a pause and see if we have questions about any of this. I know we've spoken to some of our clients about it. But if anyone has any questions, go ahead and pop those in the chat. And if you don't see any, we'll move on and tell you the latest and greatest with respect to the enforcement of this rule. All right, let's keep pushing ahead. So first, and Kirk, I'll lean on you, or if you want to start this, explain Chevron deference.
Yeah, for sure. I think we can probably partner on this for sure, because everybody's kind of taking it all in. It's so new. So not to get too kind of legal jargon on you, but when we talk case names, Chevron is a significant Supreme Court decision that has kind of set the employment landscape for a very long time. So the Supreme Court in Chevron basically held that federal courts, when they're looking at an agency's interpretation as ambiguous, they have to defer to them. So they're looking to the agency to basically say, what did you mean by this? Or how are you going to interpret and enforce it? So that's kind of been the law of the land. So the agency created the rule and the agency got to say how it was going to be applied, right? That's kind of where we were under Chevron. Well, that just recently changed, right? Like just this month, in the Loper Bright Enterprises case, the U.S. Supreme Court said, no, game over, no more Chevron, we're overriding that. And they said, really, the new standard that we're going to evaluate these agency rules is that they must exercise independent judgment in deciding whether an agency has acted within their authority. So what we've done is the agency still issues the rule or the regulation, but now we're saying the agency doesn't have definitive authority to interpret what that means. So if a court determines that that agency rule went too far, for example, with 3-year automatic increases under the FLSA, then it's subject to challenge. So I think that's where we're going to see the most significant impact here, is that you're going to see more challenges to agency rules. We just recently saw new EEO guidelines come out. I think you're going to see potential challenges there. You're going to see a court system that begins to challenge these agencies that are potentially overstepping and say, hold on a minute, that doesn't appear reasonable to us as far as the scope and the enforcement of what you're wanting to do. So I think we're going to see a lot of that change. Another area that I think is potentially going to be under the spotlight is independent contractor rules. So we're going to see a lot of those agency things start to have a little more scrutiny under the microscope, if you will. And I think we're going to see some potentially significant changes in that area.
Yeah, I think under Chevron, and Kirk's right, that was a landmark case. I think it dealt with interpreting the Clean Air or Clean Water Act or something. But under Chevron, if there was a challenge to an agency rule, a court would look to the agency to say, okay, what did you mean by this? And as long as that explanation was somewhat reasonable, as long as it was internally consistent, the court would say, okay, it's your job to interpret the statute, not ours. Now the Supreme Court's saying, no. We're the ones that interpret what statutes mean, not you, agency. So an agency can put forth a perfectly reasonable explanation. And if a court disagrees in its independent judgment, it can say that doesn't make sense to us. We're going to strike down that rule. So I think you're right. I think it's going to encourage many more challenges. So this could be a case that we're, talking about 5, 10, 20 years from now. If nothing changes, it could have a real big impact.
Yeah, I think it's really important to note too, and Eric mentioned this earlier, that again, not to get too political, but we understand that agency heads are appointed positions, right? So a lot of times what we see with things like the Department of Labor, the National Labor Relations Board, the EEO, they're going to swing with the presidency, right? So I think this gives the court a little more discretion to say, we're going to make it a little less political, and we're going to be the ones that are evaluating those type of interpretations as far as how it applies, not the agency itself.
Yeah. So that can impact things like challenges to the rules we just talked about.
Yeah, the first challenge that we saw was in the Ryan case with the Eastern District of Texas. Not a significant impact for us across the board. I think we were waiting to see more challenges to the FLSA, and this was very limited in scope. So again, very recent, July 3rd, where the court issued this preliminary injunction. But this application just really applied first to federal employers, not all employers in the state of Texas. And again, I think we're even now further interpreting the scope of that rule. So very, very specific to the case itself, but I think it's an example of the type of challenges that we're going to continue to see under this agency ruling.
Yep. And there's another one out of the Eastern District of Pennsylvania that is pending. There has not been a ruling yet, but the court has kind of previewed and said it intends to rule by July 23rd, which is, just under a week away, on whether the non-compete ban is enforceable. How they carve that or how they craft that opinion, if they side with ATS tree service, for example, they could say, hey, we think this same argument applies for every employer across the country. They could say that. They could say, well, we're going to limit it just to Pennsylvania. We want other courts to weigh in. Or they could limit it just to ATS tree service. We don't really know. But I think we included it here as an example of there's a lot of stuff going on with this. And we really need to wait and see how this shakes out. Interesting to know that both of these cases were filed before that Chevron case. So I don't even know how that's going to impact these cases, that are already pending.
Yeah, Marcus, you know this from your practice experience. You're always trying to cite to precedent to argue your point. I think what we're going to see now that we have a Supreme Court case is more and more people are going to use that to leverage to make a stronger argument. So I think the challenges are much more likely going to come now. Yeah.
I think that's all the content that we have. So it looks like we have about 5 more minutes. And so I want to give you a cue if you're attending and you have questions, didn't understand this, or can you repeat that? Or what about this scenario? All fair game. Throw those in the Q&A chat bubble, and I'll keep an eye out for them. Also, just remind you what I said earlier. We are recording this. You will get a copy of the recording if you registered. If you want a copy of the recording because you did not register, please shoot me an email. I will make sure that you get it. If you have questions that are specific to you, send those to me too, and I'll find someone smarter than me to help answer them, like Eric or Kirk. So just 5 minutes left. I hope this was informative. I hope that it gave you a perspective on some things that are coming down the pike and may impact your business. So I'm not seeing any question. We did get a thank you, guys. So appreciate that.
Hey, Marcus, real quick. No,
Yeah.
I know we did get a question that was posed like right before we went live on
Oh yeah. Yeah.
pay transparency.
Yeah.
So obviously not really the focus of the conversation today, but if that's something you'd love to hear about, I'm sure we could do another Ask the HR Expert again with
Hmm.
people smarter than me. But just, I know we got a couple minutes left, but
Yeah.
really that is so state specific. It's driven by state law, right? So
Yeah.
each individual state. So California, for example, is going to require transparency in all postings and all positions across the board for all employers, where that isn't going to be the case in other states. So reach out to us if we can answer questions on that. Or like I said, if that's something that you would like to hear more, I'm sure we can direct that to Marcus and we can get a whole presentation put together on that topic.
Sure. We do have a question here. We've got someone who says that they have agreements with employees that contain all three types, non-compete, non-solicit, non-disclosure. And the question is, if all this goes through, can we just essentially waive the non-compete? What do you think about that?
I would strongly recommend. Go ahead, Eric.
No, I was just gonna say, and Kirk, I'm sure you'll add more color to it, but I would just say, I mean, there's a process in waiving those non-competes, and there's specific a process, as you kind of share, there's a process of what employers need to do as far as getting rid of those non-competes and communicating to employees that have non-competes, but really looking at your non-solicit, non-disclosures and making sure they're not written as a non-compete in a sense, because there's potential to be risk there if there's specific language that, even though we're calling it a non-solicit, non-disclosure, if it reads as a non-compete, we could be potentially having risk there. So just really carefully reviewing that with counsel would be my recommendation.
Yeah, absolutely. I think that's the advice, is that I wouldn't recommend just waiving portions of their agreement, because basically what you're trying to do is enter into a new agreement. So I think the opportunity there is, again, going back, good communication, conversations with those employees. And if you're going to take the non-compete out, then partner with your law firm, partner with your HR partner, and get your language stronger in your non-solicit and non-disclosure areas so that you can provide the protection that you're losing under your non-solicit agreements.
Great points, guys. I was just going to remind, I think, Eric, you mentioned it. What do employers need to do? There's a process. Employers need to provide notice to employees with existing non-competes that they're not going to be enforced. And so I think depending on the language of the agreement, it's possible, theoretically possible, to maybe just provide the notice and say, hey, you have an agreement with all three. We're just going to pull that non-disclosure out. A lot of these agreements have what are called severability clauses, where if one portion is not enforceable, the rest of the agreement stays in effect. Obviously, you probably a conversation with your lawyer. But to Kirk's point, if you wrote an agreement that had all three of those prongs and we're going to pull one out, probably the whoever wrote the agreement wasn't thinking of, well, we're going to pull this out. So you probably want to strengthen the other two to make sure you're protected. Great question. All right, we are at time. So thank you very much to those of you who joined. A lot of great questions today. We'll do it again. We'll do it again soon. I would anticipate only more questions will arise in the future. So thank you for attending. Thank you for the questions. Thank you to Kirk and Eric for sharing your perspectives on this. There's a lot to cover here, but what we can do is share what we know and what we've learned in working with clients. So I appreciate you guys for jumping on and doing that. Thanks everyone. We'll go ahead and end here, but we'll see you again soon. Thank you.